Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you and welcome to today's podcast. My guest today is Eric Solotoff. Mr. Solotoff is a partner with Fox Rothschild, LLP in their Roseland, New Jersey offices. Fox Rothschild is a multidiscipline law firm with offices in New York, New Jersey, Connecticut, Delaware, Florida, Pennsylvania, California, and Nevada. Eric is a member of the firm's litigation department and the family law practice group. As such, much of Eric's practice pertains to various aspects of matrimonial actions, custody issues, and the negotiation and preparation of prenuptial and divorce agreements. Eric is also the editor of the New Jersey Family Legal Blog. Eric, welcome, and thank you for appearing on Forensic Perspectives.
Thank you for having me.
Eric, recently, acting New York State Supreme Court Justice Saralee Evans issued a decision in the case entitled Simkin versus blank. The issue in this matter pertained to Mr. Simkin's interest to reform his divorce agreement with his former wife because he was one of the many victims of the Bernard Madoff PONZI scheme. Ultimately, Justice Evans dismissed the complaint in its entirety. Eric, you've posted an article on your blog that's entitled Madoff Mess Hits Divorce Court. Who is Stephen Simkin, and what was his cause of action?
Stephen Simkin is a partner at Paul Weiss, which is a very large New York City law firm. And in his case, his cause of action was for reformation of the divorce agreement. Essentially, he claimed that there was mutual mistake between he and his former wife, and alternatively, that she was unjustly enriched by receiving the funds from this Madoff account.
This case was not unusual when compared to other matrimonial actions. The couple was married for approximately 30 years, and Stephen Simkin and his wife spent nearly 2 years debating the value of their home in Scarsdale, his interest in his law practice, and the value of his Manhattan apartment. The only thing they didn't really argue about was the value of their portfolio held by Bernie Madoff, and if I remember correctly, the value was worth about $5.4 million. In the 2006 divorce settlement, Mr. Simkin paid his wife, Miss Blank, some $2.7 million, which represented what they thought at the time was his wife's ex-share of the investment portfolio. Why did Justice Evans dismiss this case?
Justice Evans essentially dismissed this case because as of the cutoff date, the agreed-upon date, end date for the valuation of assets, Mr. Simkin could have taken the money out of the account on that day. And because it was arguably available for him to remove on that day, he could have taken it out and then could have had the value of the asset. So for that reason, the case was dismissed.
Now, how does this differ from when an investment portfolio or another asset may change, increase, or decrease in value due to market fluctuations?
In my opinion, the real difference is, in this case, there really wasn't an asset. With any asset, there is certain risk. With real estate, and as we've seen in the current economy, real estate going down, in a divorce agreement, it may have seemed wise to keep the house at some point, and now it's not such a wise decision. Same thing with stocks and bonds and other financial accounts. At some point, there was actually an asset. In this case, seemingly there was never an asset, and the parties were defrauded by Mr. Madoff, them and many thousands of other people.
Well, if this change in the stock portfolio was actually a result of stock losses, it's highly unlikely that Mr. Simkin would have at all requested or compelled the court to consider any relief. How is this different from when an ex-spouse holds on to a home where the value decreases?
I think it's different because there is no asset here. Clearly, if you make a choice to hold an asset and it loses value, I think it's different than there not actually being an asset, which turned out to be the case with many of the Madoff victims.
Now, my understanding, you're the attorney, but my understanding is that in an equitable distribution matter, it's generally not modifiable. Is there ever an exception in a divorce proceeding?
Typically, there is no exception. Certainly in New Jersey, where I practice, equitable distribution is absolutely not modifiable. Sometimes the court can modify the terms of equitable distribution in terms of if there's a payout and someone is having a hard time or has the inability to meet a payment schedule, but they won't reduce the amount of equitable distribution. Equitable distribution is not modifiable, unlike support or custody or parenting issues, which could be modifiable based on changed circumstances. There are no changed circumstances as it comes to equitable distribution.
Mr. Simkin's papers alleged that because of the Madoff account turned out to be valueless, the spirit of the agreement was broken. Is there any validity to his position? And if so, what legal principles can we follow to support his argument?
I think that the position has legal merit. I believe that if both parties believe that there was an asset that existed and it really didn't exist, that would be a mutual mistake. And reading the complaint that was filed in this case, it's clear that the parties reviewed the account statements, talked about the account statements, and did not have any dispute as to the value because they both believed that there was money in this account. Two problems, I think, arose for Mr. Simkin as it relates to this lawsuit. And one is that he liquidated some of the account in order to pay this equitable distribution, evidencing that there was money available as of the cutoff date in this account, so it wasn't solely valueless. The second was that at any point subsequent to the cutoff date, up until the time of the PONZI scheme hitting the news, he could have actually removed the money, and it doesn't seem like that was in dispute at all.